Now, Jacob Zuma's corruption trial supposed to be underway in the High Court in Pietermaritzburg. The former president and French arms company Thales are facing charges of fraud, graft and racketeering relating to the 1999 arms deal. Well, there's a matter of possible postponement that's been discussed in court this morning. Watching that is my colleague, eNCA senior reporter Siphamandla Goge, going to give us the latest here on the midday view. Siphamandla, good afternoon. Welcome. I think in about 22 minutes or so, the court is supposed to resume, according to what we heard just now when they broke for a short lunch. And there's been this argument that's been advanced by the defense, Advocate Mpofu, saying the accused has a right constitutionally and by law to be present in court. And of course, today they were supposed to have been hearing that Billy Downer matter. And the former president is arguing that he wants to be present in court even for that.
Absolutely, yes. That's been the first order of business for the court today. You know, they had to start with hearing that application brought by former President Jacob Zuma and his legal team. Simply put, they are arguing that these visual proceedings are hindering on his rights. They are affecting his rights to be physically present in court. They are arguing that they have been unable to consult with him and that he is far away in a Scotch prison. They need him closer so that they can consult and take instructions. They are basically saying it's not working for them, and the former president is eager to come here. According to their application, that 25-page affidavit that they filed or submitted yesterday, they are arguing that, well, the former president is going to launch an application to have the lead prosecutor in this matter, Advocate Billy Downer, recusing himself. So therefore, the former president would like to be physically present in court. He may exercise his right to basically give evidence in that application or during that hearing of the recusal of the lead prosecutor, Advocate Billy Downer. Now they are saying if he is far away, it will not work for them, and they are saying constitutionally he has a right to be physically present in court. They are arguing that the virtual proceedings or the usage of video and audio link is usually reserved for bail hearing purposes and when the matter is going to be postponed, not in what could be a lengthy trial. Advocate Mpofu arguing strongly there. Let's listen to him.
The last thing you had in mind when your lordship sanctioned that proceedings was that procedure would be done in the absence of the accused. That is the intervening fact that was unknown to either your lordship or to any party at the time. Secondly, the lordship could not have known that 2 months later there'll be some unrest which will necessitate that proceedings in court should be dealt with in a particular way or not in a particular way. There's nobody, I mean, none of us were sangomas that could have foreseen something like that. Thirdly, your lordship could also not have foreseen that come the hearing of that procedure, there will be conditions which make it difficult for the accused person to consult with his legal practitioners, such as the prevailing conditions. All those things, my lord, are the things. So the fact that your lordship sanctioned a particular procedure, as they say in economics, all things being equal, has got nothing to do with the current situation where the things are not equal.
The view of Advocate Mpofu, of course, there's Siphamandla expressing very firmly that they believe that the president's rights would be undermined if he was not present. But for the prosecutor, Vem Trengrove doesn't agree. He believes that the former president, in his words, is present in this hearing as much as any of the people who are participating virtually.
Absolutely. While I'm answering your question, I'm going to ask my colleague Joe Komane to come with me to show you outside the court precinct here. You've got members of the SANDF manning and guarding this precinct here. Of course, they are supporting the police who are leading in terms of ensuring that they prepare for supporters of former President Jacob Zuma who may come here and protest. We have seen a deployment of public order police all the way from the Western Cape, and you've got members of the SANDF who are out here to ensure that there is law and order. We're going to turn back now and show you the other side there. just near the court's entrance, you will see the 2 police inyalas are parked there to ensure that no one accesses that court entrance without any verification and order. Well, the state in this case is arguing that there is nothing wrong with having these proceedings virtually because the former president is provided with all the facilities. He is able to connect, he is able to follow the proceedings well. In fact, if I were to quote Advocate Vem Tremgrove there, arguing that this is a Stalingrad 27. Of course, Stalingrad is associated with former President Jacob Zuma's so-called delaying tactics. The state is adamant that there is nothing here that is wrong. The process is smooth, it's fair, it's taken into account all the former president's constitutional rights. So therefore, they don't see what is wrong with them. In fact, proceeding with the court proceedings using the virtual platform, and they are arguing that the process has been fair, has been smooth. Let's listen to Vemchenkov.
He desperately seeks to avoid answering the charges of corruption, fraud, and money laundering made against him. He raises objections again and again. The objections raised today are objections which were raised and decided against him by the Supreme Court of Appeal in the spy tapes case and by the full bench in the stay of prosecution. You will have seen the analysis included in our answer to the application for a postponement, that 135 paragraphs of his heads of argument in this case, in support of the special defense, are paragraphs cut and paste from his application for leave to appeal to the Constitutional Court against the full court judgment. It merely illustrates 2 things. Firstly, that this is simply a rehash of old complaints dressed up as a special defense under section 106(1)H. But it is merely a ruse. It is a recycling of old complaints. Of this debate on a virtual platform is a public hearing to which the public have access, and in the presence of the accused. He is present on the platform, a la De Beer, so that with respect, it is a competent mechanism, it is an appropriate mechanism, and it is one that the court is not merely entitled, but submit with respect, obliged to adopt in the exercise of its discretionary powers to ensure that fairness is done, not only to the accused, but also to the public interest in the prosecution of, particularly in the prosecution of any serious crime, but particularly in the prosecution of corruption, fraud, and money laundering. So we submit that the process is a lawful and competent one. Let me then turn to our submission that the request or demand for oral evidence is unfounded and unnecessary.
Okay, Siphamandla, those arguments have been made, and now we're waiting for the court to resume at 1:30. What's next?
We expect that former President Jacob Zuma's legal team, led by Advocate Masuku, will now respond to what the state has been saying through Advocate Vem Tremgrove. Then after that, the state will respond. We expect that the proceedings should be wrapped up by the end of business today, but it's very likely that the judgment will be reserved in this matter. However, Judge Pitkun doesn't have much time in terms of ruling on the matter, so it could be that judgment may be reserved. However, we'll only know once the court is done with its business.
Thank you very much. Siphamandla Goge, they're outside the High Court in Pietermaritzburg, eMkungundlovu in KwaZulu-Natal.